Where do you start with Judge Beryl Howell's 101-page decision against Donald Trump, finding yet another policy of his to be blatantly unconstitutional under the First, Fifth, and Sixth Amendment, his attack on law firms? Where do you begin? You begin at the beginning with Judge Beryl Howell, who is an eloquent writer, who's powerful, where the opinion has momentum and has urgency. And in the first 4 pages gives a history lesson, a needed history lesson, and contextual lesson to Donald Trump and the American people. You begin at the beginning with Judge Beryl Howell. She found unconstitutional, blatantly unconstitutional at that, Donald Trump's efforts to blacklist law firms, try to shake the timbers and the foundation of our democratic society, which independent judiciary requires there be independent lawyering. But by blacklisting Perkins Coie and Jenner and Block and Wilmer Hale and the rest, what do you have? You have an out-of-control president who, in the words of Beryl Howell, quoting from Shakespeare, wants to kill all the lawyers he doesn't like. More importantly, she goes back to the Federalist Papers. She goes back to the framing and the foundation of this country, and she takes a special privileged moment to chastise and wrap the knuckles of those law firms who bent the knee to Donald Trump. In fact, she uses it as a justification to grant on summary judgment the permanent injunction that she just issued. We are waiting on 2 other judges, similarly, I am sure, to follow Judge Beryl Howell's lead. We're waiting for Judge Bates to make his ruling in the Jenner and Block law firm decision. And we're waiting for Judge Romeo to make his decision in the Wilmer Hale case. I am sure they will follow Beryl Howell, who I'll also show you a clip at some point in this hot take of Beryl Howell actually speaking at a conference so you understand who we're talking about. Having been the chief judge of the D.C. Circuit Court during the Jan 6th prosecutions, during Donald Trump's prosecutions. She knows everything there is to know about Donald Trump and his abuse of power. Having watched it, she was responsible for the Mar-a-Lago search warrant ultimately. She was responsible for stripping Donald Trump of his attorney-client privilege along with his attorneys because she found it was more likely than not that he committed crimes. She was responsible for the ultimate judgment against Rudy Giuliani for lying about the election. There's no better author of this opinion than Beryl Howell. Let me read to you from the first couple of pages, and you'll understand what I'm talking about. She has a separate order commanding the federal government and Pam Bondi and Donald Trump and others to do certain things at certain times to take this law firm Perkins Coie off the blacklist. But listen to what she says at the beginning of her opinion, her memorandum opinion. No American president has ever issued executive orders like the one at issue in this lawsuit, targeting a prominent law firm with adverse actions to be executed by all executive branch agencies. That means taking away their security clearances so they can't do business with the government, taking away their right to represent clients before the government. That's where the Sixth Amendment privilege, where you get to have counsel of your choice, that's been destroyed by Donald Trump's executive order because you can't hire Perkins Coie. She says, this action draws from a playbook, the judge continues, as old as Shakespeare, who penned the phrase, "The first thing is we do, we kill all the lawyers," from Henry VI. When Shakespeare's character, a rebel leader intent on becoming king, hears this suggestion, he promptly incorporates this tactic as part of his plan to assume power, leading in the same scene to the rebel leader demanding away with him, referring to an educated clerk who can make obligations and write court hand. She continues, the importance of independent lawyers to ensuring the American judicial system's fair and impartial administration of justice has been recognized in this country since its founding era. In 1770, let me just take a moment here. This is the first 2 paragraphs of the opinion. This isn't like some dry, dusty text somewhere. This is how she starts the opinion. In 1770, John Adams made the singularly unpopular decision to represent 8 British soldiers charged with murder for their roles in the Boston Massacre and claimed later to have suffered the loss of more than half his practice. I had no hesitation, he explained. The bar ought to be independent and impartial at all times and in every circumstance. When the Bill of Rights was ratified, she continues, these principles were codified into the Constitution. The Sixth Amendment secured the right in all criminal prosecutions to have the assistance of counsel for defense. The Fifth Amendment protected the right to the aid of counsel when desired and provided by the party asserting that right. This value placed on the role of lawyers caught the attention of Alexis de Tocqueville, who, in reflecting on his travels throughout the early United States in 1831 and 1832, insightfully remarked that the authority entrusted to the members of the legal profession is the most powerful existing security against the excesses of democracy. Lawyers are the firewall against an out-of-control, lawless president and others. She continues, the Supreme Court, too, has recognized the importance of lawyers to the functioning of the American judicial system, since informed independent judiciary presumes an informed independent bar. And citing cases. She says on page 3 that this case presents an unprecedented attack on those foundational principles. She then cites to the actual executive order from March 6th issued by Donald Trump against Perkins Coie to penalize and stigmatize the firm. She says, in a cringeworthy twist on the theatrical phrase, let's kill all the lawyers, the executive order says, its approach is, let's kill all the lawyers I don't like, sending the clear message, lawyers must stick to the party line or else. She then cites in footnote 3, I'm going to do a separate hot take on this. She then basically wraps the knuckles of other law firms that have bent the knee, including Paul Weiss, Skadden Arps, Latham and Watkins, and the list goes on. It's about 20 different law firms, including a law firm that I used to work at to start my career, who bent the knee and gave Donald Trump $1 billion worth of tribute to get him off their back. And here, Judge Beryl Howell is saying, shame on you for not standing up for yourself and bringing this to a court for review. And we'll talk more about that at my next hot take. She then goes through. Let me continue here. And let me take a break for a minute before I continue with this particular order, which is so powerful, and give you a little taste of Beryl Howell. Let me give you a little taste because, often you just see these dry opinions or you see photos. We'll put some up here of Beryl Howell, but I want you to hear her in her own words. She gave a speech recently to a woman's white collar bar event. Let me roll that clip for you about the importance of there being true facts and that we all agree to those true facts and the impact on the court system. Let's roll the clip.
Having a very surprising and downright troubling moment in this country, when the very importance of facts is dismissed or ignored. That's a very risky business for all of us and our democracy. The historian Heather Cox Richardson, whose book I've been reading, explains in her new book, which is a bestseller, so many of you may have already read it, Democracy Awakening, that burying facts with false history telling is one of the keys to the rise of authoritarianism. As she bluntly puts it, big lies are springboards for authoritarians. She cautions in her book's opening line, it's the very first line, America is at a crossroads, teetering on the brink of authoritarianism. And she echoes this thought in her closing line, that we are at a time of testing, and how it comes out resting, as it always has, is in our own hands. In between those 2 points, in the first line and the last, her book focuses on historical facts to set the record straight about recreated and imagined conspiratorial retellings of our country's history, recent and long ago. My DC judicial colleagues and I regularly see the impact of big lies at the sentencing of hundreds of individuals who have been convicted for offense conduct on January 6, 2021, when they disrupted the certification of the 2020 presidential election at the U.S. Capitol. As district court judges, we are all about the facts.
That's the Beryl Howell I'm talking about. Let's go back to her order about the violations that she found, blatant violations of the First, Fifth, and Sixth Amendment. On page 12 and later, she does what all the judges do, and Donald Trump has never learned not to do, which is Donald Trump's own words being used against him to show animus, to show vindictiveness, to show retaliation against all law firms. And again, the audience for this is you and me and the Trump administration, the world and history, but also the judges that are working on their own orders. I'm looking at you, Judge Bates. I'm looking at you, Judge Romeo. Judge Leon. You're working on your orders about the law firms. You should be following this order. You should just say, for the reasons cited in Beryl Howell's decision, reincorporated here by reference. You should just do a Me Too opinion, seriously. But let me continue. He says that she quotes to a Trump social post, a Truth Social post on May 5th of 2024. Hillary Clinton, recidivist election theft conspirator regarding 1992. This is what he posted on Truth Social recently. I'm talking about a year ago, May. The Clinton campaign used a law firm as the intermediary for tens of thousands of dollars in payments to a private investigator whose task it was to obtain the silence of a woman who claimed to have had affairs with Bill Clinton. They paid their law firm, Perkins Coie, this is the same law firm here, which retained the firm Fusion GPS and its contractor, former British spy Christopher Steele, to generate the farcical Steele dossier. So this is him attacking Perkins Coie. She goes over those particular types of attacks later as well. Now, let's get to the heart of the decision. She says that the executive order on page 52 retaliates against plaintiff for First Amendment protected activities, including their political viewpoint and statements favoring diversity and inclusion. You can't go after a law firm because you don't like the clients they represent. You don't like the fact that Mark Elias used to work at Perkins Coie or Michael Sussman used to work at Perkins Coie and they had a role representing Democratic interests, or Hillary Clinton. That's not going to make it here. That's not a justification to put them on the crap list for the federal government and destroy their law firm in retaliation. Or that they run a diversity, equity, and inclusion program to bring in people of diverse viewpoints into their law firm. Again, not an ability to retaliate against them and take away their security clearances and basically put them out of business. Now, just to make clear, this is the same firm, Perkins Coie, that Donald Trump sued in Florida 3 or 4 years ago in front of Judge Middlebrooks in West Palm Beach, Florida, with Alina Habba. And what happened there? The case was dismissed with prejudice and penalties and sanctions, and the judge awarded $1 million to the other side, having found that the case had completely no merit against Perkins Coie and Hillary Clinton and others, and that they should be sanctioned $1 million. And Alina Habba and Donald Trump paid the $1 million. So now that he's president, let's go after them with an unconstitutional executive order. So that's the First Amendment analysis. The Fifth and Sixth Amendment analysis are sort of tied together. That is, you are preventing people, the client side of this equation, not to have the lawyer of their choice because you've taken Perkins Coie out of the game and out of business. If I want to have Perkins Coie represent me in front of the federal government under the current executive order until blocked by Beryl Howell, I cannot. That's a Fifth Amendment violation. I get the lawyer of my choice. That's a Sixth Amendment violation. I have the lawyer of my choice when it comes to something where my liberty is at stake. Now, here's what she rules. That's the highlights from the 101. But let me read to you from the order that goes hand in glove with this. This is the power of a federal judge. She gets to command on high executive officers. She said that she's declaring on page 1 of the order that executive order entitled Addressing Risks from Perkins Coie is unlawful because it violates the First, Fifth, and Sixth Amendments of the U.S. Constitution and is therefore null and void. Defendants are permanently, that's the Trump administration, enjoined from implementing or enforcing it in any way. They are directed to rescind all guidance to all staff about enforcing that provision. They are directed to tell all independent contractors that it's been rescinded. They are directed on page 3 to cease any security clearance review of Perkins Coie. And this is some of my favorites here. F on page 3. Defendants, the Office of Management and Budget, and Russell Vought by name. Russell Vought is the architect of Project 2025. He's a MAGA right wing, and he runs our national checkbook at the Office of Management and Budget. He has now been directed to identify all government goods, property, material, and services provided for the benefit of Perkins Coie that he has directed to stop. In other words, the property rights they've been taken away from them, and they are now ordered to reverse and rescind the cessation of any such service or material or services. Back in the game, back on the saddle because of Judge Beryl Howell's order. Defendants are directed to communicate to every recipient, letting them know that Perkins Coie is out of the doghouse effectively. On page 4, a direct order to Pam Bondi, the Department of Justice. Defendants, the U.S. Department of Justice, Pamela Bondi as U.S. Attorney General, Russell Vaught, Office of Management and Budget, are additionally directed to provide a copy of this order to everybody, direct the recipients to comply with the terms of the order, notify the recipients about the order and they're required to comply under penalty of contempt, give everybody a copy within 7 days. The court retains jurisdiction, and she said this is a final and appealable order, meaning if you don't like it, you can go take it up to the D.C. Court of Appeals and up to the United States Supreme Court. Beryl Howell should be on the United States Supreme Court. And in my next hot take that'll follow this one, I'm going to talk about, in particular, how important it was for her to call out those law firms that bent the knee and bent over instead of fighting, like Jenner and Block and Wilmer Hale and Perkins Coie and Williams Connolly that brought the case. Because the lawyers needed a lawyer. So Perkins Coie got a phenomenal law firm in Williams and Connolly, major firm in D.C., to bring the case, and she complimented them and patted them on the back too. I'm going to talk about that more in my next hot take. You're here already on Legal AF. Hit the subscribe button, and I've got Legal AF's got a brand new Substack. Can't get your fill of Legal AF? Come over to Substack. We're continuing to build that pro-democracy channel and that Substack location as well. So until my next reporting, I'm Michael Popok. In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories, the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.